Now, the way this is being designed, this is not Cooper versus Erwin, but this is a hypothetical case. It's called Chad Oglethorpe, not me, Chad Oglethorpe versus the Harris Wald Township, and about what's happened since Brown and Cooper versus Erwin. This is a difficult case in the sense it's not a traditional way that the Supreme Court would get a case, but this is the Supreme Court that will be hearing it. And it's also different because we have 10 justices rather than 9. And you'll get a chance to hear from each of them and their comments during the course of the presentation. What is unusual about it is they decide where we are today on trying to achieve integration. Is that they will take a look at these facts, and instead of going behind to deliberate and critique it, they will actually have their deliberations right here in front of you. So you'll hear what they have to say about the issues today and how they have an impact on what we're trying to do.
Okay. We'll hear argument in the case of Oglethorpe versus Harris Wald Township.
Thank you. Good afternoon. Chief Justice Breyer, and may it please the Court. 58 years after this Court's decision in Brown versus Board of Education, American public schools are increasingly separate and unequal. Demographic realities and the decisions of this Court make racial integration an impossibility in most American cities. However, equal educational opportunity remains a constitutional imperative. As to the case before you today, I wish to make 2 arguments.
But
First,
you said racial equal opportunity in education is a constitutional imperative?
yes, Your Honor.
And where are you getting that from? Education is not a fundamental right.
This Court in Brown versus Board of Education said that today, education is the most important function of government.
But
But
it's not a fundamental right.
No, in Rodriguez versus San Antonio Board of Education, this Court said that education is not a fundamental right. But even subsequent to Rodriguez, in Plyler versus Doe in 1982, this Court again recognized the fundamental importance of education without using the label fundamental right.
Children.
Pardon?
As pertaining to illegal alien children and how government could spend its money for them.
That was the holding, Your Honor, in Plyler, but the language of the majority opinion talked about the fundamental importance of education for all children. And that, of course, was what Brown versus Board of Education was about. And as to the case that's before the Court this afternoon, I wish to make 2 arguments. First, the desegregation plan adopted by the Harris Wald School District violates equal protection under this Court's decisions in Swan versus Charlotte Mecklenburg Board of Education and parents involved in community schools for Seattle School District Number 1. Second, the disparities in funding within the Harris Wald School District violate equal protection, including under this Court's decision in San Antonio Board of Education versus Rodriguez.
If you're right, what does that do to the fundamental interest that you just spoke about in terms of equal educational opportunity? How do we achieve it?
Your Honor, at the very least, what I'm saying in this case is disparities in funding within a school district violate equal protection. And the record here shows that there are substantial disparities in funding between the Martin Luther King School and the Pebble Creek School. And the intra-district disparities are clearly a denial of equal protection.
Okay, but the question remains, how do we achieve the importance of educational equality that you began your presentation with?
This Court should hold that the disparity in funding within this school system deny equal protection and order an equalization of funding within the schools within this district.
Wait a minute.
Counsel.
You're the complaining party here. So it's your burden to convince us that the plan put in by the school district is unconstitutional. And I'm trying to understand what's your foundation. Are you saying merely because race was among the factors considered? And I'm assuming if that's your argument, you're looking to concerned parents or parents involved. And parents involved was a racial balancing case, and that's what bothered the plurality there. This isn't a racial balancing case, is it?
Your Honor, I have 2 separate reasons why the desegregation plan is unconstitutional. One goes, as you say, to the Court's decision in parents involved in community schools for session number 1. There, 5 justices on the Court said that the government may use race as a factor in assigning students to schools only if it can show that no race-neutral alternative can succeed. If you look at page 8 of the record, it specifically says that race is a factor in assigning students within the Harris-Wald School District. Under this court's decision, that can be done only if there's a showing that no race-neutral alternatives succeed. There is no showing by the school district in this case, no such finding by the lower court, which makes the plan
Wait,
unconstitutional.
there are 5 justices? Can I just follow you? There are 5 justices in parents involved that say you cannot use race as a consideration?
Yes, Your Honor. Chief Justice Roberts' opinion, in a part that was the majority opinion, Justice Kennedy concurred in part and concurred in the judgment part, but this is the part he concurred in, said that the government may use race as a factor in assigning students to schools only if it can show that no race-neutral alternative can achieve diversity.
Okay, so let me give you the part of Justice Kennedy. Let's assuming we do a count vote thing. Justice Kennedy said diversity is a compelling educational goal. Attendance zones may be redrawn. School districts may act to avoid racial isolation. So now if you put Justice Kennedy's notions with the 4 dissenters, what does that do with your position?
Your Honor, there were 5 justices and parents involved to say that diversity is a compelling interest. We do not challenge that diversity is a compelling interest. However, if you'll notice what you just read from Justice Kennedy, it does not include assigning students to schools based on race, absent a showing that there's no race-neutral alternative that can succeed. And what the school district would have to show here in assigning students based on race is that there's no race-neutral alternative that can achieve diversity.
Is there anything in the record that shows that the school system considered race-neutral alternatives? Is there anything in the record that would show that?
There is nothing in the record here, Your Honor, which is why, under this court's decision and parents involved, it's impermissible. And as I said to Justice Edwards, I do want to point out there's a second reason why the school district plan is unconstitutional. In Swan versus Charlotte-Mecklenburg Board of Education, this court said that busing is permissible for reasonable distances, and now I'm quoting the court, so long as not hinder the education of students. The 2 students in this case, Chad Oglethorpe and David McNeil, were each bused 90 minutes each way. The facts in the record show it did interfere with the educational opportunity of the students. This is not a reasonable amount of busing. And so on that basis, under Swan, the desegregation order is also unconstitutional.
You have said, but you have said you agree that there is, that the plan, you're arguing that the plan is unconstitutional, but you want an order from this court equalizing funding?
That's correct, Your Honor.
And what is your basis for that? What would be your basis, predicate for that order, for such an
Equal
order?
protection, Your Honor. In Rodriguez, this court dealt with whether or not inter-district disparities violate the Constitution.
And how is that analytically distinct from the situation we have here? Why should it matter in terms of framing a remedy?
This is an intra-district disparity, and it makes an enormous difference. In Rodriguez, and a year later in Milliken versus Bradley, this court talked about the importance of respect for school district lines and about the ability to have inter-district remedies only if there is an inter-district violation. This is an intra-district disparity. Nothing in Rodriguez would be the contrary, that such an intra-district disparity in funding violates equal protection.
But we said in Antonio that it's not just how much money is spent, but how the money is spent. And it sounds to me like you're asking us to enter an order that would take us back to separate but equal. You're saying we can't fix the fact that these school districts are separate, spend the money to make them equal, even though we have said there's no way to measure equality by the amount of spending.
No, Your Honor. What Brown versus Board of Education was addressing, state laws that required separation of students. That's not what we're dealing with here. What we're dealing with here is a reality of demographics. When you look at, for example, Dallas, where the students are 4% white, or Chicago, where the school system is 8% white, or Los Angeles was 8.4% white, or Boston, where it's 13% white, there is simply nothing a school district can do or court can do to achieve racial integration.
Let me ask you one thing, so I understand your position. I won't say one thing because I don't want to limit myself. Could the school district have used a lottery here?
Yes, Your Honor.
Okay, and the results would have been essentially the same.
Well, Your Honor, if the lottery
Because we have one largely all-black one largely all white, and a mix. And so the odds are likely we're going to end up with the mix that you're saying they cannot achieve doing it the way they did it.
Well, Your Honor, two things. First, if the lottery involved busing students 90 minutes, I believe that would be inconsistent with this court's decision in Swan.
But that's not a constitutional violation to make a child stay on a bus a long period of time. It may be inconvenient and may even violate state law, but it's not a constitutional violation.
No, but Your Honor, busing is a remedy. In this court in Swan, at 402 U.S., at pages 30, 31.
No, wait, stay with the lottery.
Okay,
It's
I'll
a
go back to the lottery.
And we get essentially the same results. And we now have a diverse school. That's okay, right? Even though the kids are being bused 90 minutes.
That's true, because race is then not used. However,
Well, wait, is race used here? I thought they did this by neighborhood.
No, Your Honor.
Did they say race?
Yes,
or did
Your
they
Honor.
say
On
neighborhood?
page 8, towards the bottom of the page of the record, it specifically says that one of the factors that's used in assigning students is race. And that's the tension between what the school district did here and what this court said in parents involved in community schools is permissible. And Justice Edwards, to go back to your question, there is a huge difference between a lottery in assigning students and the use of race in assigning students under this court's decision in parents involved.
Let me ask you,
The school district said we're using a lottery because we know we will get the racial diversity that we want.
Your Honor, that would be different, because this court has said when the government acts with the purpose and the effect of a racial classification, that's to be treated that way. So if the government creates the lottery with the purpose of achieving racial diversity and with the effect of achieving racial diversity, that's the same as a racial classification, going back to this court's decision in Washington versus Davis in 1976.
let me ask you this. Would you view the equalization of funding to be a race-neutral alternative?
Yes, Your Honor. By
Why is
definition.
that not present in every case then? Such that if that's a race-neutral alternative, then every case is obviated because it's available, the equalization of funding.
Your Honor, there are two separate considerations. One that you point to, the equalization of funding. And if the same amount is spent on each student's education, black or white, by definition, that's race neutral. The other question is one of racial integration. And thus, it's our position that while racial integration cannot be constitutionally achieved, at least on the record in this case, equalization of educational funding can and should be achieved on the record in this case.
Why shouldn't we?
Are we just to assume that equalization of expenditures will somehow result in a parity in performance? Or
Quality of opportunity.
Is there anything in the record that establishes that?
No, Your Honor. At the very least, I'd say that poor children should have the same chance to be disappointed by the spending of money on education that wealthy children have always had.
No.
But, Your Honor, there are many studies that indicate that there's a relationship between educational expenditures and educational achievement. In fact, I think common sense for all of us who are parents would confirm that. All of us would rather that our children be educated in a class with 20 students and one teacher than with 45 students in one teacher, and that does come down to educational expenditures.
Counsel, should we adopt Justice Douglas's concurrence in Keys, and should we be making a difference between de facto and de jure segregation? Because you've talked about using funding to achieve a particular purpose, but isn't it required that there be some state imposition? And are you asking us to simply conflate de facto and de jure segregation to achieve a particular result?
As I said to Justice Wynn's question, I do think it's important to distinguish between the disparity in funding and the lack of racial integration. As the disparity in funding, it is de jure in this case. It is a school board appropriating different money for these two different schools in the same district. In terms of the racial separation in this district, it would be de facto. And this court has drawn a distinction between intentional and unintentional discrimination, not only in Keys, but in the whole line of cases going back to Washington versus Davis.
Could I go back to Judge Edwards' question? I'm sorry. About the extent to which the analysis here fits into Justice Kennedy's concurrence in parents involved. Would your response to the question that Justice Kennedy proffered, for instance, the drawing of attendance zones. Is the only thing that prevents, in your view, the attendance zones that we're looking at on the record before us from the attendance zones that Justice Kennedy posited in his concurrence, the fact that you don't understand there to have been a consideration of less intrusive alternatives? And isn't that something that's fairly easily remediable?
Yes, Justice Duncan, the difference is there was not the consideration of race-neutral alternatives. Whether or not it's easily remediable, I don't know, Your Honor. The record doesn't tell us. What's key is, in Parents Involved, Chief Justice Roberts wrote an opinion for 4 justices rejecting that diversity was a compelling interest with regard to elementary and secondary schools. However, Chief Justice Roberts wrote an opinion for a majority. Justice Kennedy joined this, saying that race could be used as a factor in assigning students only if there was a showing that no race-neutral alternative could work. There is no demonstration in the record of this case that a race-neutral alternative could succeed.
What do you mean? Give me an example of a race-neutral alternative. In a society with such impacted class and caste demographics, how can there be a race-neutral criteria? It can't be high school average, I would submit, because of the studies that show a correlation. It can't be family income because of the correlation. If you pick any criteria, be it residential neighborhood, family income, you're going to be using a proxy for race. How can there be a race-neutral criteria? And help me find an example of one.
Your Honor, it may be possible in some school districts to simply redraw attendance zones to achieve desegregation. And so, for example, rather than cutting a city horizontally, maybe if you cut it vertically, you'll be able to achieve desegregation. There's nothing in the record of this case to indicate that that would be sufficient, certainly without the tremendous busing that's involved here.
What would drive the zones, the lines that were drawn, what would drive those lines? Wouldn't they have to be driven with an eye toward the racial demographics of where that line was going?
But I think what Justice Kennedy was... Right. Well, but I think what Justice Kennedy was saying in Parents Involved is there's a difference between drawing attendance zones with an eye towards race and assigning individual students to schools with an eye towards race.
But the question is, what factors are you considering when determining how to draw those attendance zones? What are the factors that determine how you draw them?
Undoubtedly, many factors are used in drawing attendance zones,
One
including,
of which is race.
Well, and Justice Kennedy doesn't preclude the use of race in drawing attendance zones. The language from that Justice Edwards quoted indicated that. However, I think it's also important to indicate that there are other factors that are used in drawing attendance zones, including convenience of the students. I don't want to lose sight here what I said to Justice Duncan, that in Swan, this court specifically said, if there's going to be busing as a remedy for desegregation, it has to be busing that doesn't hinder the education of students. This record shows that both of the plaintiffs' education was hindered by the extensive busing.
Let me ask about that, because why shouldn't we abrogate our decision in California versus Johnson and apply a different level of scrutiny? Why shouldn't we say that since the governmental practice here impacts both blacks and whites exactly the same, both groups suffer the same level of adversity, the impact is not based upon any pernicious motive. It's not driven by animosity or racism. Why shouldn't we simply say, where that is the case, the standard to be applied is not strict scrutiny, but either rational basis or maybe heightened scrutiny?
Your Honor, this court has repeatedly said that any use of a racial classification warrants strict scrutiny, because any use of a racial classification conveys messages within society that are pernicious. California versus Johnson that you mentioned is exactly on point. That's where the California prison system used race in assigning prisoners, presumptively segregating prisoners when they were first brought into the system. And Justice O'Connor's opinion for the court there expressly said strict scrutiny is to be used. If nothing else, as Justice O'Connor says in her decision in Croson, it's to smoke out the impermissible motives.
But I'm convinced by your argument, given the difficulty of trying to find a race-neutral alternative, that maybe what we said in Johnson and those lines of cases was wrong. Maybe we shouldn't use heightened scrutiny here.
Your Honor, I think the problem is, as I was saying, that demographic realities, as well as decisions from this court, are going to prevent effective desegregation, racial integration in almost every American city. That's why this court should turn to equalizing educational opportunity.
Mr. Chairman, Chemerinsky, let me focus you on the concept of equality, which is what you seek. As I understand it, some significant amount of the inequality intra-district stems from an inequality in private sources of funding, private donations from parents, and the like. Is that correct?
Yes, Your Honor.
What are we to do with that? How are we going to ensure that there's an equality of the sort that you seek with that inequality in private sources?
What does a remedial, in other words, what does the remedial order you would have us issue look like?
This court should issue an order that says the funding in each of the high schools in the district, that's what's before us, should be equal. If that then means that some schools are getting more money from private sources, then the school district would have to equalize that in the other schools through tax systems.
Right, so that's a pretty radical. No, I'm just saying that
I
my question specifically is that's what I think everyone wants you to focus on, because you're correct that the record says in assigning they use race explicitly. So I can see what you're asking for in the first part. You're saying, say that this use of explicit race violates parents involved. Now, that may not get you too far, as people point out, because they'll get the same result, if not through a lottery, by drawing district boundaries. But the second part becomes important. And the second part, you are saying, not even what New Hampshire said. I mean, you're saying that the Constitution of the United States, looking at the authority to the contrary, provides a right in the Constitution to an equal expenditure for every child. Now, this has nothing to do with race anymore, or it may be, but that happens to be a fact, but nonetheless. Whether it's a poor child, rich child, poor parts, or is it just intra-district? And what happens if the parents want to spend more in a math class? Or what happens if one is a technical high school or a scientific high school? And what happens if, and we can imagine, how are district judges supposed to implement the rule that you will tell me, and we're in the process of replying, that you're advocating as a matter of constitutional law?
Your Honor, many states following this court's decision in San Antonio Board of Education versus Rodriguez, as a matter of state constitutional law, ordered equalization of expenditures among schools. Since this has been done under state constitutions in some states, there is precedent that federal courts can look to. And what I'm saying is that Rodriguez said that inter-district disparities in funding do not violate the Constitution. But nothing in Rodriguez denies that intra-district disparities violate the Constitution.
But as many, if not more, state courts said that that is a matter left best to legislative and educational policymakers, and not the courts. And I'm trying to get a handle on what that would look like, and I'm still not sure how you'd implement it.
I think, Your Honor, it's implemented by an order from this court that the schools should have the same per pupil expenditures, at least absent some compelling justification for deviation.
That won't equalize. The minority district here is so far below the white district, you would end up with what I assume you would argue is unequal expenditure in favor of the minority students,
Well, no,
in
Your Honor.
order to get them equal.
Your Honor, at the very least, we should bring the minority students up to the level of the white students.
Just to follow up on that, we have a school district that is very well-meaning, and it discovers that there are more minority single parents or leave nobody home at 3 o'clock. And so what they say is when families are not home at 3 o'clock because both parents are working, we do is we have special reading programs, game programs, or whatever they have. In other words, they make special efforts which happen to be concentrated on the poorer sections of the community because that's how it works out. And you're saying, that's forbidden?
Your Honor, I would be delighted to defend such a system.
No, I would too, fine.
But, Your Honor, we are so far from that.
What we want to know is what is the rule.
We are so far from that in the Harris-Wald School District and in most school districts in the United States because exactly the reasons that Justice Duncan points out, we're in a situation where the poorer areas have less in the way of parental contributions, less resources than the more wealthy schools in the same district.
What is the constitutional source for that kind of a remedy to equalize that situation?
The Equal Protection Clause of the 14th Amendment, Your Honor.
Can we do what you request, counsel, without making education a fundamental right?
Yes, Your Honor, I believe that you can. Because I believe, going back to the language in Plyler versus Doe, this court has at least recognized the fundamental nature of education. And I think you can say there is no rational basis, let alone no important or compelling interest, for the kind of disparity in school funding that exists within school districts today.
But there is also language in Milliken versus Bradley that says there is no more fundamentally local interest than the operation of school system.
Exactly, Your Honor. Milliken versus Bradley said there cannot be inter-district remedies to school segregation without an inter-district violation. We are not here dealing with the Milliken-Rodriguez situation of across district lines. We're here dealing with tremendous disparities within a district, and not disparities that are favoring the poorest students, not giving them more compensatory education, disparities that are very much favoring the wealthier students.
Let me go back to your assertion that Justice Kennedy bought into some of what the plurality was saying because he joined the judgment in part. It almost looks like tongue-in-cheek, because Justice Kennedy says, look, diversity is a compelling educational goal. Racial composition can be considered by the school district. Racial isolation is a factor to consider to determine whether or not a child is being denied a fair educational opportunity. Now, you see, you point to the two kids who are before us claiming our educational opportunity is impaired because you have to ride 90 minutes. The school district said there are many more kids who are in the segregated schools whose educational opportunity is being impaired. And so we want to mix them.
My time
Your red light is on, counsel.
May I answer briefly so
yes.
I save the rest of my time for rebuttal? Chief Justice Roberts wrote an opinion that was in part for a plurality, but in part for majority. Justice Kennedy concurred in the judgment. In the part where he was concurring, he said, race can be used as a factor in assigning students only if there's no showing of a race-neutral alternative. There's no such showing in this case.
Okay.
I begin with a disclaimer. It's not easy for me to say, may it please the court, and not answer at the same time. So if I find myself asking a question or making a point and answering it, you'll have to forgive me. I'm not used to this. Likewise, when I looked at the district court record, which was so ambiguous, I decided to write my own district court decision. So, with those disclaimers, with respect to the challenge to the use of race in the Wald Township, I read Justice Kennedy's concurrence, and I read the case law supporting this very differently than my opponents. At the very least, and it doesn't say a great deal, the courts have suggested that diversity. There were two components of Brown versus Board of Education. One is the component that we all know about, which was the admonition to stop state-sponsored segregation of schools. But the second component, which is written in much more broad terms, which is education is the foundation of good citizenship. Brown was about citizenship. It is a principal instrument in awakening the child to cultural values, in preparing him for...
Ms. Gertner, is there a...
Excuse me?
That was in the context of state action, of state laws.
No, I understand.
Requiring segregation.
And that has been, to some degree, transmogrified in Justice Kennedy's concurrence and in the language of Justice Breyer as well, to suggest that diversity, strength comes from people of different races, creeds, and cultures.
Your adversary, Ms. Gertner.
Did you call me Judge Gertner? No.
I can call you Judge Gertner if you want.
This is your work?
I answer to anything at this point.
Your adversary made some hay of the fact that on this record, at least, there is no evidence that the school district undertook some race-neutral analysis or alternative. Is that correct? And if so, what should we make of that?
Well, that's an interesting question. If the goal here is not racial balancing for its own sake, but to create an environment that is a diverse environment, if it's about citizenship, if it's about learning how to
Well, what about a lottery? That was alluded to as well. That's a obviously race-neutral alternative, is it not?
That would be a race-neutral alternative. It's not, but it would be episodic. It's not clear that it would be that it would achieve the goal here. In other words, if the ultimate goal...
What is the goal, I think, is one question. And if you're not starting from an identified point of a disparity, how can we know, or how can you know, more importantly, when you've achieved what it is you seek to achieve?
Well,
what is it you seek to achieve?
Are you you saying segregated schools are inherently unequal or integrated schools are inherently good? What is your starting premise?
Well, I'm taking a point that a school can decide, as a fabulous district court judge did in the Lynn school case, a school can decide that education is more than just numbers and test scores, that education in a multiracial, globalized world means that you have to participate in a class with someone of a different race or culture or ethnic group or economic background next to you. Let me give you an analogy, which again, I don't know whether or not—
I think already Grutter gives you that. You're talking about the importance of diversity. But what do we do here with the adverse impact of this plan on these two students, on McNeil and on Oglethorpe?
Well, the question is where the burden lies. In other words, on the one hand, the question is whether or not the people challenging this need to suggest that that burden is widespread. Obviously, it's not widespread.
Well, should we then ignore the hardship that's befalling two students just because of the fact that one is black and one is white, and just say, you're not there yet. You've got to get to the term critical mass. That brilliant judge who wrote Lynn talked in terms of critical mass. Do we have to wait until there's a critical mass of misery before a court can become concerned?
But again, let me roll this back a bit. If one believes, particularly through K through 12 education, as opposed to elite schools and law schools and medical schools, that the school board can say there's a value to citizenship here, there's a value to multiracial citizenship, that's an independent value to some degree, then the least drastic means is achieving a multiracial—
Well, all right, I'm counsel. Some of us have the tendency to think that our dissents are the law.
If it were only true.
The fact is, even dissents that refer to Lynn in other cases are dissents. That means they're not the law. So if, in fact, we look at parents involved, 4 justices say never explicit race, and Justice Kennedy says a system that, what he calls, according to a crude system of individual racial classifications, is a different matter, and he joined that third part. And when you look at the examples that he gives, not one of them uses race, except that they use things that are correlated with race. But they don't mention race. Now, a dissent wisely pointed out that that was not a sensible distinction. That dissent was a dissent. And so what seems to be is that you can, in fact, divide neighborhoods, draw attendance zones, use strategic site selection, and allocate resources, target this, that, or the other thing, but not use race explicitly. Now, I don't know how you read those 3 paragraphs there without coming to that conclusion that that is the law. So therefore, I look at this, and it says that it uses race explicitly, and that seems to be what 5 members of the Supreme Court have said you cannot do. Now, what do we do about that?
Well, the question is whether or not Justice Kennedy's concurrence, dare I say, is less than clear in this regard.
Where is it less than clear?
Well, he says
it lists 10 things that are correlates for, but not explicitly mentioned race, and then it condemns, in the last sentence, the explicit use of race.
One way of interpreting the paragraph that says, with general recognition of the demographics of neighborhoods, allocating resources for special programs, recruiting students and faculty in a targeted fashion, tracking enrollments, performance, and other statistics by race. So what my understanding is that he was suggesting, as to some degree the Grutter decision suggests, a multifactorial approach in which race is not dispositive, but one of many factors. And arguably, that is what's going on here, which is to say—
But if there's a correlation of, let's say, 0.8 amongst all of those factors, how can you say that race is not dispositive? We just use different proxies for race and say, well, we're not looking at race, we're looking at income. We're not looking at race, we're looking at where the person lives. We're not looking at race, we're looking at the quality of the educational opportunities where the person is. All of those things are proxies for race.
proxies for race is a different way of saying correlate with race.
Correct.
They plainly correlate with race. Whether they're proxies for race is a different matter. One can say that it's important to have a diverse environment that is in terms of income, educational background, et cetera, and race being part of that. And even if the other factors are correlates of race, your purpose here is to create an urban, multiracial school. This is actually more complicated. There are 4 zones. Zone 1 is mostly white residents. Zone 4 is mostly black and low income. Zone 1 is high income. And then the 2 and 3 are mixed. This is every student, 50% of students from each zone goes to one school and 50% from the other. In order to determine who's going where, you consider race, family income, standardized test scores, parents' educational level, and sibling preference.
Now, are you trying to
are
you trying to tie this to Justice Kennedy's language toward the end? It is true. It's a little bit confusing. What the Chief Justice referred to is in the beginning, but at the end, he says a compelling interest exists in avoiding racial isolation, an interest that a school district, in its discretion and expertise, may choose to pursue. Likewise, a district may consider a compelling interest to achieve a diverse student population. Race may be one component in that diversity, but other demographic factors, interests may be considered too. Is that what you're asking?
That is exactly what I was thinking.
Why didn't you say that?
Well, I was going to get to that. I have an analogy, sort of a metaphor, not an analogy, a metaphor, which I wonder would make sense here. Let's assume there was a one-room school, one building was the school, a public school, and there were 2 rooms in it, room 101 and room 202. And everyone in the area came to this one school. And all the black kids went to 101 because they self-segregated. And all the white kids went to 202. Could the principal of that school say, mix it up, guys? 50% of you go to 101, 50% of you go to 202, because I don't want to preside over a school system in which the people sitting next to you are the people that look like you. I want it to
No, you would try alphabetical first, probably.
Alphabetical would be, well, except that if the, again.
That's what alternatives are, counsel. The problem is, in this country, we don't have a good history of letting legislatures put race-specific classifications in play. And the question is that parents involved clearly said, when you're doing so and denying a benefit based on that classification of race, that that's not allowed. Now, we can find metrics and correlation that they would race, but that clearly seems to be flies in the face of what you're doing in your school district.
Legislature is one thing. One of the other things that is a history that is implicit in our history since Brown versus Board of Education is the deference, once they're acting in good faith, given to school boards to make decisions. And this is children within a public school, within an urban environment, have to be sorted somehow. And the question is, what's the sorting mechanism, and whether or not that's a multivariate, multi-determined concept rather than race alone, and whether those factors key in to an educational purpose.
At what point will you have achieved the level of diversity that makes for that perfect blend of mix that creates the good citizen?
Well, you know, in that regard,
doesn't it have to keep getting tweaked?
Yes.
The more successful you are, the less you need it. So it's an ongoing, it's never quite there, is it?
Well, again, if success is defined in perfect integration, if the issue was integration, and that would be one thing. But what I'm suggesting is key to these decisions, to Bruder, to parents involved, is the notion that we can try to set up a classroom that maximizes educational opportunity for all children, and part of that is learning. I remember when I had my kids going to school, you know, the first few grades were works and plays.
But what I'm still grappling with is how, I think you've told me who defines it. I'm still having trouble understanding how it's defined.
Well, the only way that it can be defined is what comprises educational opportunity, the record in this case. There are better records, and if I had written the decision, it would have been better. There's no question about it.
No doubt.
But the question is, it may well be that in these days, every part of compelling state interest has to be litigated. So in other words, the question of the relationship between the demography of a classroom and its relationship to educational opportunity needs to be litigated. That was litigated in the Lynn case. What is the relationship? Does it matter? Well, yes, there are studies that suggest it makes an enormous difference if you're the only black kid in the class. It makes an enormous difference if the class is overwhelmingly minority, not necessarily in the way Brown versus Board of Education talked about it, which is feeling inferior. Okay. But
I believe my colleague, Justice Donald, has a question.
Well, yes. Thank you. Since you mentioned Brown, I wanted to ask you, does the principal in Brown simply abhor the mere existence of segregation in schools, irrespective of whether a state is responsible for it or not? And depending on your answer, I would ask, in this case, is there anything wrong with using simply a socioeconomic metric for, as the basis for school assignment?
Well, it's not clear that there would be nothing wrong in that. The question is whether this plan offends the Constitution. The fact that now the question is whether or not the existence of some alternatives suggests that this is not the least drastic means.
But that is the question, isn't it? If you can possibly achieve, by use of the criterion that Justice Donald referred to, then it seems to suggest that there is a less intrusive, a less clearly race-conscious or race-defined mechanism. Therefore, your proposal can't be constitutional because it has ignored that option.
There are two answers to that question. One is it may be that, for example, an income-based approach would have the same disability that we talked about here, which is there may well be kids who will be bused more than 90 minutes. In other words, you can't...
But not based on race.
But not based on race. And so the question is whether or not that will achieve the same kind of educational opportunity that this school board determined was essential in this case. And that's ultimately what it comes down to. Income is part of the consideration here. Standardized test scores, family income are part of the picture here. And at the end of the day, in effect, race is part of this.
Counsel, let's...
Does the dialogue that's been going on for the last half an hour or so illustrate that perhaps we've all fallen into a trap? And the trap is that we as an institution are confident to make intelligent, efficacious educational policy when we really are not. And you have a situation where, for example, across the campus you have an education school that has been looking and wrestling with these issues. How do you achieve quality of outcomes? What's the best way of funding deficits and so forth? They've been studying this for 50, 75 years and haven't come close to solving the problem. Why do you think, do you think the trap is that we are wrestling with a set of issues that we simply have no at the end of the day, no real institutional competence for?
I think that the concept, for example, of a compelling state interest married to the concept of deference to school boards is an uncomfortable mix. On the one hand, compelling state interest invites courts to balance and weigh. I mean,
it's not just uncomfortable, it doesn't seem to work.
Well, the question is, what's the constitutional floor? There may be better alternatives just now to achieve better education, but this is the question is whether this approach is constitutional. All that I'm suggesting is that one way of looking at Lynn, the case, one of the cases that's cited here, one way of looking at Grutter is the goal is defined in terms of the remedy in effect. The goal is a multiracial environment, and that's a goal that makes difference.
Let's return to the basic premise of diversity, which is something we've thrown around here in a generic fashion as to what is diversity. And I take it your premise is that facial diversity alone achieves viewpoint diversity. Is that correct?
No, I'm actually not talking about viewpoint diversity.
What then is your goal if the compelling interest insofar as education, if you're not there to achieve the viewpoint type of diversity, does facial diversity alone achieve it?
Well, again, studies suggest, and the studies in Lynn suggested, that there were students who came out of this environment who say, you know, it's now more natural for me to have a black colleague than I ever had before.
How many black colleagues does that person have to have to generate that feeling? And how do you measure it?
Right. And if you ask me to get into critical mass, I won't. But the answer is that there has to be some mix, and that taking race into account, along with factors A through D, is not illegitimate. And it's not illegitimate because the ultimate goal is a multiracial, learning how to grow up in a multiracial environment.
Given the globalization, at least in terms of the prospect of learning in different circles and individuals associating to a greater degree, is it not possible to achieve viewpoint diversity without actually having facial diversity?
Viewpoint diversity doesn't resonate as much in K through 12 as it does in a university or a law school environment. In K through 12, it may well be the symbolism of going out to play with someone who is simply different. In other words, I'm not sure that the two concepts are equivalent. Viewpoint diversity on the one hand, and simply learning how to grow up in a multiracial world.
Ms. Gertner, can I press the constitutional floor a little bit? In this record, as I understand it, there are also ability groupings within a school. So in addition to intra-school district issues, there is segregation within schools based on placement of students in advanced classes rather than other classes. Is it the school district's position that it can also use race in connection with determining who gets into an advanced class by way of an ability grouping?
That's not in the record. So far, the record that we're dealing with is just a sorting record.
Is there anything, if we adopt your position, that would prevent the school district from doing that?
When it comes to merit-based decisions, that's where I distinguish between elementary schools and law schools and medical schools. When it comes to merit-based decisions, it seems to me the equation is different. We're now just talking about who's going to be next door.
What if all of the white students in a school were in advanced courses and really didn't mix at all with the black or other racial minority students? Would the school district then be entitled, given your position, to use race as a factor in placing some of the minority students in the advanced courses, notwithstanding merit issues?
I would have trouble with that. I certainly think that would be, because that's a different issue than sorting, as I said, than who should be sitting next to one another. That's an issue that it may be, for example, it's much like the employment discrimination cases that deal with testing. Then it may be, sure, let's look again at what our criteria is.
But given the correlation, use your word, not proxy, between income and achievement, and the studies have shown that that, in fact, is what tends to happen, that once you get a building that is diverse in whole, within that building, certain things start to happen. Black students tend to get assigned at a higher ratio to through tracking processes to non-advancement kinds of courses. If your premise is correct, what would prevent the school district from doing that? In fact, wouldn't they have to do that to make sure that the educational opportunity in terms of the multicultural experience in the advanced courses was as rich as you're saying it needs to be? Wouldn't they have to step in and make sure that the school had not created little enclaves within itself so that you have a, if you look at just who's assigned to that school, it's pretty diverse, but within that school, it's totally not diverse. And we could end up with a situation where your plan achieves absolutely nothing except students traveling 90 miles to get to a building in which they're segregated.
I can see a continuum, which our cases describe. And the continuum could be, is there anything wrong with providing the black students who are likely to be at the bottom of the class with additional help? No. Anything wrong tutoring them? Anything wrong looking at the standards by which we define who got into that class? No. Quotas, mixing that explicitly at that level, probably yes. But that's not what we're talking about here. We're talking about an assignment zone, an attendance zone, which is who's going to be sitting next to one another.
I want to be sure you have some time to deal with the other part of this argument. So, counsel, let me ask you, assuming that we read that you cannot do this because it's explicit use of race, then what do you think of the possibility of, let me put it in the most least threatening way, suppose the court were to hold, so I don't know why the school is spending such diverse amounts of money and so spending so little on the poor neighborhoods and so much on the wealthy neighborhoods. This is a single school district. What do you think of the proposition that where poverty in a particular region of the city, of a single school district, is highly correlated with race, then under those circumstances, we will presume that a significantly unequal expenditure, a gross disparity of expenditure, unexplained by clear educational reasons, does amount to race-based discrimination. And therefore, the Constitution forbids it. You have to have, in such an instance, within a single school district, more equal expenditure among the poorer and the wealthier areas of the city, at least, reserving all else to a future case, at least where that poverty is highly correlated with race.
That would be engrafting, essentially, a disparate impact model on this record. In other words, you're saying the net effect of property tax-based
it's a single school district, after all. The
But
money comes from a single group of people. It goes into a single pot. And I don't know why they're spending this money so disparately.
But the net effect, but you're saying that they have decided, and we believe in local control, particularly financial issues, they have decided that property taxes in a particular area will fund the schools. And you're saying the net effect, one would have to say that the net effect of that decision is to discriminate on the basis of race. The problem with that approach, looking at it that way, would collide with Washington v. Davis. Would collide with a model that rejects a disparate impact in a 14th Amendment context.
But there are studies that indicate that the intra-district disparities often come because the best, more experienced teachers go to the non-minority schools, the schools that need them most. And so they're being paid more, so the per pupil expenditure is higher. Could a court say, the one thing we can surely do is to say, get some of those good teachers in the schools that need it? Can we do that?
I don't think that you can do that. I think that the concern of Rodriguez with respect to sort of the incoherence of poverty as a basis for an equal protection challenge maintains. How far do you go? What comprises equalization? And I think it was your point, Judge Edwards, that in a situation where there are gross disparities, equalization may not be remotely sufficient. In other words, that it may be that you have to spend more in order to equalize. The court, speaking of competence, very much in the Rodriguez line of cases, found itself unable to determine what equality of expenditure.
So why don't you give us a prescription? If we disagree with you about parents involved, some of us may, some of us may not, what's the prescription with respect to the equalization solution that your adversary has foisted upon us?
I don't see how Rodriguez can be upended without a conclusion, on the one hand, of a finding that poverty is a fundamental right, a right not to be poor is somehow a fundamental right, or that education is a fundamental right, triggering strict scrutiny.
Go with the lottery and assume that the money will follow the white students when they're bused, right?
The lottery is a random, is the notion of telling...
But given this weird district, it's likely you're going to get a diverse two high schools, and there are some of us who think that if you put enough white students in the bad school will no longer be bad.
Well, in this situation, though, presumably the schools are relatively evenly divided, black and white. We don't actually have demographic figures. In Lynn, as I think I described before, in fact, because the percentage of minority was not more than 50%, you really could have a balanced school system, and that was not necessarily the case. We don't have enough in the record with respect to that. But I think the question is, if a school system decides for educational reasons, not for race, not for...
Wait. You said for educational reasons, not for race, but you spend a lot of your time arguing that one of the important educational things is cross-contact, multi-cultural contact. So how can you separate those two things, not for race and not for educational?
There have to be findings with respect to the impact, this as an educational goal. It can't be assumed. We assumed it in Brown versus Board of Education when the court talked about the importance of citizenship and learning how to be good citizens. We assumed it. I think that today we have to test it to some degree. What's the relationship between learning in those environments and learning in segregated environments? What's the relationship between learning in a diverse setting and not? I think it has to be tested and not necessarily assumed.
Well, you assumed that when you put the plan in place, though.
But, excuse me?
Didn't you assume that when you put this plan in place? Wasn't that one of the driving things behind this plan?
I'm assuming that there were findings that were so elaborate that they comprised 84 pages. That Gary Orfield testified below, just as he did done in the Lynn case, because actually, one of the things that was clear in the Lynn case, and I think it's an important point to make, is that the things that we assumed can't be accepted anymore, and they do have to be proved.
Would the funding issue be more manageable and less problematic constitutionally if the goal were to bring everyone to the same level of being provided a sound basic education as some state constitutions do, as opposed to always equalizing, continually equalizing upward to meet the push of private resources?
We have problems under the constitutional framework of the federal constitution, which is an equal protection analysis. The states that have done that have had in their constitutions a provision for about adequate education. And they have sought to implement what comprises an adequate education. And that has not been an easy path. But certainly an equal protection model is in effect too gross a model, too gross a measure to be able to deal with these kinds of issues. And I think that that's what the Supreme Court has said.
Counsel, I don't understand. You come to this court, you know that there's incredible disparity in funding already in an intra-school district, and yet you want to use a race classification to deal with what I'll call soft issues of isolation, getting on kumbaya type issues. But yet you know that the pressing problem in education in this country are low test scores, retention problems. Aren't you like, you're arranging deck chairs on the Titanic, aren't you? Shouldn't you be using your money to have better schools and address low scores? The French call it triage. Why do you call
it separate but equal?
Yeah.
That there are better ways of doing this. There may well be better ways.
No, using race classification is not a better way based on parents involved. We know that.
Well, the question is race among, it is not entirely clear to me from Justice Kennedy's concurrence, this gets back to what we were saying before, that a multi-factor test, particularly in K through 12, where the goals are different than in a medical school or a law school, et cetera, would not be appropriate. Whether that's all to make our schools better is a separate issue completely. Whether this is sufficient constitutionally, it seems to me is the matter in front of you, and whether a school board should be deferred to under the circumstances and how to sort
What's
the
before us, it
black and
seemed
white
like you're involved in racial balancing.
That's not what they say they're doing.
On this record, that seems to be the main thing you're doing is racial balancing, because you haven't made a case for doing anything else other than impacting adversely to students, and otherwise continuing a disparate funding system.
All right, and we have to be brief, counsel, because the red light is on,
Okay.
so could you answer briefly?
The program in this case was not race balancing. 50% of students from each zone went to one, 50% went to the other. As part of the decision of which individual would go where was a number of issues, including sibling preference, parents' education level, standardized test scores, family income, and race. So the enterprise here was to create two diverse schools by all measures, family income, educational background of the parents, as well as race. They made a finding that was consistent with their educational mission, and that's the finding that I would ask you to uphold. Thank you.
Thank you very much. 5 minutes reserved.